Hi, Judith.
Hey, Barb.
Yeah, I did at 11 today. But I was with my mom in Austin all day. I just got home at 4:30. I just got home at 4:30.
Same song, second verse. Yeah, you're good. Yeah.
Hey, Tim?
Yes.
How can a person on Facebook Live ask a question?
They can post a comment.
Oh, yeah, post comments. Zoom, they can use chat.
Hey, Steve. Hi, Jody.
Hi, how are you? Good.
Feel good?
Yeah, I'm fine.
Good.
I had a great day.
Good job.
Yeah,
Something good happened?
yeah, I played.
You play golf?
I played golf. I went out for lunch with friends. I went to the apple orchard, went to the pumpkin patch, and saw my mom. No, we were in Rockton. We went to
Oh, okay, cool. What's happening? Beautiful day.
yeah.
Same old thing, different day.
And the pumpkin patch was the family farm.
Oh, really?
Yeah, so I took everybody out there.
Oh, how nice.
How are you? Hi, Dave.
How are you? Good.
Sean, the questions for the section on AUCC. Are you going to address those, or you want Dave to address those, or?
I can, well, between us, we can figure it out.
Here.
Articles. Oh, this one right here?
Polly.
Oh, okay, I say this one here is easy.
Some we just can get back to later.
Hey, Steve. How are you?
Hey, Steve.
Good.
Sure. You can be where you want to be. Hi, Fern. How are you? Good. Yeah.
I totally forgot about it.
Oh, wasn't that nice?
That was nice.
I drove around the neighborhood yesterday, went to every single house and returned the check. Hi, Pat.
Hi, Joey.
Steve, you want a copy of those? Oh, this? Yeah. Yeah.
Why did it stop now?
I had just washed mine.
Dave,
Yeah.
when you do your sections, I need you to stand right there and not move,
And
no
there.
matter what. If George Strogas wants you, you can't move.
Barb might throw something at me.
Yeah, I know.
You know, I had to get closer because
We don't.
I'm scary
Okay.
far away, I'm really scary close up.
Oh, goodbye. I got you a new.
Backwards here, and even gonna address, a question on this one right here. Okay, does that mean that's not important? No, it's not.
We've had so many things going on recently that, you know, I mean, you name it, I mean, everything.
Here we go. Ed's talking. Ed and Kathy are there. They're talking to Jody right now, I think.
I can't get my
Anybody? Oh, listen, little go. You just keep and go up to 25 people.
Bad, and, I went out there and it got worse than I thought it was.
They have to come in here.
What about town hall meeting? Oh, for Camden? Yeah.
Hey, Steve, Johnny,
And I'm trying to make the best of it, just said isn't answering any of my questions.
Steve, what do you see on your screen?
But I'm going to this one. This 20 minutes covered in foil. Wrapped in foil. How do you think I do that? Like, do a big potato?
You'll want a new.
Oh, I guess, yeah. Or do you think I could just open it in a pan and bake it with foil over it? That's what I'm thinking, right? Yeah. Or cookie sheet?
Live on Facebook.
Sean, who do you need to mute?
What?
Someone talking?
I'm trying to figure something out right here.
Yeah, state it.
My meeting.
State it. Everything I have, every document here has a date on it. Yeah, I know. We worked a lot on the house. We have a new shed.
Okay.
And, we did a lot of boating, a lot of outside.
Yep.
And those always change.
So this goes.
Yeah, I mean, you're property worth.
Oh,
I do inside.
we don't.
So.
Bill needs to come to my place.
Well, he does maintenance freelance.
Yeah.
And then, but he also works with, a guy out of Houston who works for me.
Jody.
And does the design and for free. But he knows what plants and animals.
We have building permits that are issued by AECC that do not go before the.
So it's more than just look.
Oh, yeah.
It goes
And he makes sure that there's flowers.
other items.
At different times of the year.
she's saying here, you know, that, huh?
Perimeter rocks.
Right, we made it a committee because they are making decisions on behalf of the association. Issue. A couple went to the association from a business standpoint, and not every permit is.
I went up through my school, and I just loved the whole thing. Yeah, they're working on the flat.
Right, and we talked about the appeal process last month, and make them on that, so with the recommendation, legal counsel to leave it the way it was.
Okay?
Oh, wait, what?
Right, you said.
Yeah?
Yeah, Friday was okay, so I missed it a little bit. Sure.
15 machines.
You're supposed to be starting.
Hi. Hi, Michael. Oh, 50/50?
I emailed Tom today and I said, we screwed up. He said, yeah, he said, WWE gets a lot of money for this.
Well, the best thing that could happen was the first meeting, because everybody, the first meeting was a shit show, because everybody heard about it, and people are, they wanted to hear about it. It's perfect. Like the Trump debate. Too bad. Hey, I can live in 2011 institution, but it's like, oh, like, there's still water in the wood. I hear that all the time. Okay, ready?
What did the
Bob,
original,
gonna start now.
what did the original covenants say here? It just said the ADCC before, and it did not include the board, is that correct?
The old was, because of the Not-for-Profit Act, we had to change it. Is this about appeal?
Well,
This is about, the common property, the reserve
Okay,
property.
you can look in here at one of the old ones.
The appeal thing, we've already resolved that through legal counsel.
Try looking in here and see if you can find it. This is in 2019. Are you ready?
Ready.
All right. Good evening. Thank you for attending our second town hall meeting. Let's stay here. I'm Jody Ware. I am one of the volunteers on the legal commission. In a few minutes, I'll introduce the other members. Because of suggestions from participants at the last town hall meeting, we asked participants, those who are on Zoom, if you have a question, please push the chat button at the bottom of your screen. On the right-hand side, you will see a box. You can write a question in that box. Okay, now that I address the Zoom participants, I need to ask, can the Zoom participants hear me? Thumbs
Yeah.
up?
Thumbs up.
Yeah, I mean, they're saying yes. So.
Yes? Okay. So that brings me to those who are on Facebook Live. You can place a question in the comment box. We do have someone who is monitoring the Zoom and Facebook Live questions. If you are here in person this evening, we ask that you come up to the mic to speak. Last time, people could not hear what the audience was saying. Also, please state your name because they did not know who was talking. And then I want you to know the moderators this evening will be standing here because once I move to that side, people lost me. So I will be part of the presentation tonight. Sean will be part of the presentation tonight, and Dave Ogden. So I want to introduce the Legal Commission, and I'm being very brave doing this without my notes, but our Legal Commission Chair at this time until the next board meeting is Rich Krasula. And also we have Bill Doran, and is Bill on Zoom?
Bill's on, yep.
Bill's on Zoom. We have Steve Denny, and Steve is on Zoom.
Yep.
We also have Sandra Malahi, and she is unable to attend this evening. And we have Dave Aldrich and myself.
She's
And
introduced.
we are all volunteers who have served on the Legal Commission. I also want to introduce the board members. Right here tonight, we have Tom Ohms, Barb Hendren, Steve Borst, and Steve Tribby,
Mike Harris.
and who's right there? Oh, and Mike Harris.
That's okay, I'm used to reading.
No, Mike Harris, you blended right in, Mike, and I believe that is our board representation. And then I also want to recognize Tim Brokaw, who is managing the Facebook Live and has helped to prepare a lot of this. Your latest Apple Store, your October Apple Store, is in a mailbox near you soon.
Henry is not there.
Is the legal documents and articles from the Legal Commission and Dave Allgood. So we are going to go ahead and start this evening. We're going to talk about the charge of the Legal Commission. We are a group of volunteers, and we're going to talk about the purpose of Town Hall 2, the process for approval and timeline for voting, the changes in the declaration during the last month's process, walkthrough handed out documents, presentation, our Articles 6 through 11, and we will stop at the end of each article and ask if any participants have questions. And then our next meeting and discussion, and our meeting will end at 8 o'clock. Let's walk through your documents. If you participated or picked up a packet in the past, some of the information in this packet has changed. These are living documents. The purpose of holding the town hall meeting is to get feedback from the participants. Me, as a commission, we met last night, and then to consider changes or talk about why the language is the way it is. So I always suggest state your documents. So the first one is the declaration. The second document is an easy, simplified version for what changes were made. What did it say in 2007 or 18, 17? And what does it say now? An example, you see Exhibit A, you see Exhibit B, and you see Exhibit C. And then you also see a definition sheet of what is a natural person or legal entity, and a voting member, owner, and the definition. Then there's the changes for the bylaws, the simplified version of the bylaws, and then a very important document, questions, and what we ask is that participants write down their questions, and as I said, if you're doing it live or Zoom, we will write down your questions. We take the question and we go to our meeting with Legal Commission. We review the question, and if we can make edits, changes, and then we post our responses to the questions on the ACL-POA webpage under Town Hall.
Town Hall, correct.
So we've been adding them always along from your questions at the last meeting. I realize some of you don't want to write down your questions, then we can't take it further because you need to know what you want us to look at. There are more copies of these pages if you need them. So, we're gonna talk about the declaration tonight. You can circle declaration, you can put the article, the section, and if it's the preamble or recital or exhibit, and then you can write down your questions. Okay? And then, at the very last in your packet, we gave you a copy of the PowerPoint. There is one slide that we have added changes to in the last hour. So, we'll go ahead and get started. Sean, can I have a change of paper?
Sorry. Got a last minute
Good.
request to get in.
Well, I think it's important for you to know, who's this group of people that is bringing to you proposed changes in the covenants and in the bylaws? Well, we are a commission. We have no authority other than to make a recommendation to the board. And so, we review the ACL covenants and restrictions, bylaws, board policies, and rules and regulations, and make recommendations to the board of directors and membership for changes based on current and perceived future needs of the association. We are writing these for the next decade. Your existing language, most of it is from the 2011 declaration. These recommendations include long-range planning and use of private properties as addressed in the governing documents. The legal commission shall make reports when appropriate to the membership with the objective of informing and educating the ACL-PLA regarding their recommendations. And then you can see present and past members over the past 5 years of individuals who served on the commission.
Sorry.
So, we have the recorded and amended declaration of the past. 2011, it was the amended declaration to conform to the Common Interest Community Association Act and the Ethel Canyon Lake Property Owners Association amended and restated bylaws effective November 11, 2011. And now we have the amended declaration to conform to the Common Interest Community Association Act. In 2017, without a membership vote, the board of directors were able to adopt changes to the covenant to update it to conform to SECA. And now, we formally amended and restated covenants of restrictions effective November 6, 2011, revised May 1st, 2016, and revised May 21st, 2017. The most recent changes to declarations and bylaws made were in compliance with the current law, SECA, the Illinois General Not-for-Profit Corporation Act, and Association Counsel guidance for homeowner associations. Who is our legal counsel? We have been working with Key and Costello for several years. Key and Costello has worked with us over the course of the last 3 years, and the attorneys of Key and Costello have extensive experience representing community associations and cooperative and understand the needs of property owners in homeowner associations. They specialize in homeowner associations. During the process of reviewing the 2011-2017 declarations and bylaws, the Legal Commission was coached by Keith Jones, Attorney Keith Jones. Mr. Jones has extensive experience in preparing and amending the association governing documents, such as declarations, bylaws, and rules and regulations, as well as the enforcement of the same. By having Mr. Jones review all of the ACL key documents, the Legal Commission was able to align the documents for mirrored language besides editing and advising us on proposed language. Sean? Okay. I think this is something really important to remember. The process. The board of directors did not have any input into writing the proposed declaration or bylaw. They received the document in August. So they are here during this process to also learn about the changes. So they didn't vote or approve any of it. And I think that's important to understand what their role is in this document. So they received it in August. September 19th, we went through Articles 1 through 5 of the Declaration. Our next meeting will be going through Articles 6 through 11. And then in November, we'll do the bylaws. And our goal is, at the November meeting, Legal Commission will seek an affirmative motion to send the proposed amended governance and bylaws to the membership for a vote. Okay? So please note, the board has not approved these yet. We're having the town hall meetings. We have the one September 23rd tonight, and then we have one October 21st and 28th for presenting the documents to the voting members. Town hall meetings will be recorded to place on the ACL website and will also be on Facebook Live Zoom. Questions or comments will be collected from participants to take back to Legal Commission for consideration. Responses will be posted on the webpage. And then finally, the Legal Commission will continue to meet following Board of Directors meetings and town hall meetings to discuss questions and comments. And questions and comments will be posted on the ACL webpage. Okay? Voting procedure. The proposed change in amended and restated declaration of covenants and restrictions for Apple Canyon Lake property owners needs the affirmative vote of 2/3 of the voting members eligible to vote in person or by written ballot at a meeting of the association duly called for the purpose of changing the 2017 declaration, provided that notice of such meeting shall be sent to all voting members at least 30 days in advance, and upon its recording in the office of the Recorder of Deeds, Joe Davis County, Illinois. There are 2,743 lots in Apple Canyon Lake Property Owners Association. 2/3 affirmative vote means that we would need approximately 1,830 affirmative votes in order to change the 2017 declaration and bylaws. January 2021, we will be distributing the ballots, and we will be using the assessment packet for the distribution to save cost. We will have mail-in vote or scan your vote, and right now we're also working on electronic vote system. We will set our 30-day notice will be for a public meeting February 6th, when we have the votes that we have collected counted. If we do not have 1,830 affirmative votes, then we don't adjourn the meeting. And then in another 30 days, and we've been sticking with like 29, then we have another meeting date. We continue to count the votes, and if we don't have 1,830, then again, we do not adjourn the meeting, and we set another date in March, or in April. So it just keeps going on. Okay? So that is the process. So, changes made by Legal Commission addressing member feedback. So last night, our team was all together, and we went through the questions and changes from our last town hall meeting. And so, the one change was acquisition of land, Article 2, Section 3, reserved property. The previous language states that the association may acquire additional reserved properties when deemed to be in the best interest of the association. The previous language does not describe how the association may acquire additional reserved properties. The proposed language adds that additional reserved property may be acquired by a 2/3 affirmative vote of the Board of Directors. So at the September 23rd Town Hall meeting, owners asked that the proposed language be removed and the document go back to the original language. The Legal Commission decided at their October 6th meeting to remove the proposed language and to go back to the original language. The next change, order of community instruments. Here's the question, and if you look at your document, what we're talking about specifically is right here, where it talks about the numbered community instruments. So, the first one, of course, is SECA. The second one is the Illinois General Not-for-Profit Corporation Act. Third one, Articles of Incorporation. And then we have the Declaration and the bylaws. The next one is the ACL Building and Environmental Code, and then the board-approved policies. So, the building code is adopted by the board. While the ACC might review applications, the terms of the building code are approved by the board and are a written set of guidelines and requirements that owners must follow as established by the board. Because both the board policies and the building codes are adopted by the board, the order or priority probably really doesn't matter too much between these two. If there is a conflict between a board policy and the building code, the board can correct this by changing one or the other. Since the building code is included in two sections of this declaration, Article 3 and Article 7, I lost my place. And it pertains to all 2,743 lots, while the board policy only pertains to the 9 board members. The Legal Commission recommends keeping the proposed rank at this time. Spouse. Article 5, Section 4. Couples, there was a question, what if you aren't married and you have a significant other for a long time? Can they, should we remove the word spouse? And couples need to be listed as married on the deed of the lot or show proof of marriage with a marriage certificate in order to receive the rights and easements of enjoyment in the common property. The association cannot know the status of couples who do not have a legal document stating that they are in fact a couple and should share in the enjoyment of the common properties and therefore cannot extend that privilege without those documents. We need something in writing. So if you have a girlfriend living with you or a boyfriend, they do not fall under the same rights as a spouse, because the association would not be able to manage the individual who is using the common assessments or no. And also remember, you can be 18 years old to own property. We could have a lot of changes going through there if you're going to include your girlfriend in that they're part of the common property. Okay? Next. Okay, now we're going to go on to Article 6, and you have an opportunity if you want to react to the changes, and maybe we should go back, Sean. And if you do want to make there's a comment or chat box, you can ask a question. Or if you want to speak in person, please come up to the microphone and say your name. Are we starting? Like, do you want people to come up now? only on the things that I just addressed, the changes.
I will come up on that because, my name is.
Can you wait until you're there, because
Oh,
people
sure.
on Zoom can't hear you.
I understand. Hi, my name is Deb McNamee, 13A 133 Potterborn. I think it's discriminatory. I think that you're asking people to be married in order to have rights here, and I don't understand that. So that's my point.
And I think really it's be married or, be named as an owner. So if, you know, you have 3 people buying a
So
lot.
maybe I'm not understanding the whole thing, okay? What if I want to put my husband and I are on the deed, what if we put our daughter on it?
As an owner,
Uh-huh.
she would have the same rights as an owner, going back to that sheet that describes owner, if her name's on the deed.
So these are people without their names on the deed?
Yeah, the question last time was, well, if it's a boyfriend-girlfriend situation,
I understand. And
Because
so
of the
you're not
spouse.
giving rights to the other person unless they're married?
the girlfriend or boyfriend would have to pay an ORF in order to get those rights. Just because the boyfriend is on the deed and he has a girlfriend that lives with him,
Right.
she isn't considered an owner. She doesn't get the rights just for being the girlfriend.
You would have to be married, but you don't have to be on the deed, but you have to be married.
Correct.
Right.
Now, if she was on the deed, that would mean she's an owner also. Now, she would have to pay another ORF, but
Right.
wouldn't pay one ORF like you and Phil pay one ORF.
Yeah. Well,
So-
let me ask you this question. What if you just allowed 2 things per property? I mean, it sounds so discriminatory to me that you have, who says people have to be married?
Well, it's just, or you can have your name. I could have a relationship with John Smith, and we're both in on the property, so we're both on there. Or, if my name, only John Smith's name's on the deed, my name is not, even though we are married, and I want to qualify as a spouse who can be on commissions, then, we just have to have a legal document showing that we're married.
Yeah, I understand your point. I think it's really discriminatory. That's my.
Thank you. Go ahead, Ed, please come to the microphone.
Ed Wright, 11A 238, South Apple Canyon Road. Just a real quick question, how is it addressed when your properties are in a trust?
It's under legal entity on that sheet, Ed,
Okay,
and so it's kind of spelled out what your rights are when you have the trust,
okay.
okay? So,
I haven't had a chance to.
In your packet.
yes, in your packet,
It's handled as like as a business or corporation that owns it.
Okay,
The trust or the trustees, they have to appoint a voting member, and in the documents and the way it is spelled out, it spells out who are the legal owners, who has voting privileges, so that's when it gets really kind of interesting when it comes to trusts and other LLCs or legal entities. Was you could have a trust that might have 30 individuals on that trust, but it's amongst those people to decide themselves who has the voting right for that parcel. So, the association doesn't want to mediate between 30 people over who has the right to, the privilege to vote. That would be an internal function of the trust or the corporation to decide. And it would be up to the trust or the corporation to decide who their point of contact would be, but I believe it's spelled out that the point of contact would also be the voting member.
okay.
yep,
So in other words, if you have, for instance, in my case, I am in the pecking order of the trust, I am first, my wife is the second, and my son is the third.
right.
So he would be considered a legal entity as ownership.
Absolutely.
In the absence of either one of us.
Mhm.
Okay, that was all I had. Thank you.
Okay,
We do have one question from Facebook, if Tim could read that, if they're on the process.
okay, thank you, Tim. Can you read it, please?
Yes, the question is, from Carmel Counsel. If the required number of votes are not received, will there be the possibility of proposing amendments to the document.
If they're not, is there the possibility, I mean, we will always continue as we get feedback from the membership. The legal commission will always continue to meet and look at those changes, but again, a lot of our changes, like the majority, are changes recommended by SECA, the Not-for-Profit General Corporation Act, or, the legal counsel.
That's a very interesting question. I believe I do understand the scope of that question. If we don't achieve the ultimate number of votes, or we don't have enough people, yes or no, that have voted by the meeting date, can proposed amendments be made? Well, I guess the question would be, would that be fair to the people that already voted on a document to change that document on those people that voted? So this is why it's very, very important to ask your questions now and put them in writing so that so that we know you handed them to us. We can't deny that we didn't get them, and we're going to publish them because, like I said 2 weeks ago, there may be 3 or 4 or 30 other people out there that have the same question that weren't here tonight to hear the answer, or that may not have the means to access the technology. But we have to be very careful that once we send this document out and we send the ballots out and we start collecting votes, that we don't start altering this document because we're no longer on a level playing field with everybody that submitted their votes on time.
Could you please write down that question though, Tim, so we don't lose it for,
That's a very good question.
Okay. Any other questions, and should we continue? Okay.
You can tell 11209, Canyon Road. So you can continue to have this process for asking for how long are you going to continue this?
What do you mean? Until we pass it?
I think it becomes a matter.
So it can go all the way up to, you have 10 people that will agree with you until it gets that far? Is that how long?
Well, it becomes a matter of mathematics.
So you're gonna go back to what you did, how long was it, Mark, when you did the covenants that I wouldn't sign for? You're gonna go back to that, so it's gonna be a 2 or 3 year process?
It could be.
Okay.
See, now, like I say, if you let this up to mathematics also.
Right.
Say if we get 1,010 no votes, you're done.
Yeah.
You're absolutely done, because at that point in time, you mathematically are never going to achieve the 2/3 of the voting, the eligible voting members.
Right.
So, it becomes, if you achieve the 1830, you can call it there. If you achieve a losing vote mathematically, you can call it there. Or you can, or you could indefinitely continue the process.
So, really, if you do that, the people that are voting and say no all the way through, you're gonna keep this going until you get enough to get your way, correct?
And not until we get our way, no, until we get enough qualifying votes to get a decision by the members. This is not a movement on behalf of the commission or the board. This is a proposal to correct the governing documents that we have
I've been through this
to meet current state statute. But, no, if it went on for 3 years and we had 1,900 votes and we had 1,850 affirmative, would we want to continue for 4 or 5 more years, or would we just say, we need to call this because by the time we wait another 3 years to gather up the next 900 votes or 800 votes, we're going to be doing this again?
No, because you've got to change the membership.
Right, but I
We'll
think.
always keep that process.
Right, so
of the voting member up to date.
Yeah, the time frame will have to be evaluated by the board, and also the mathematical possibility of pass or fail would be a determining factor.
Okay, for the spouse, on the legal part, has it occurred to you that you could be challenged on that?
This was information that was provided by our legal counsel.
On our legal
I
counsel.
understand that, again, I have seen court cases where it is challenged.
In homeowners associations?
Not homeowners,
Okay.
homes.
Okay.
So you might be,
Well, this, in homeowners association, is because
by
in,
wording it in this way, you could be challenged, and I don't blame them, because they would be considered just another person.
What we can do, because, now, we've had two individuals that had question on this, we can go back to K and C, I suppose, and ask them for clarification on it again. Because they're the ones that are going to be representing it, and they were the ones that helped prepare this portion of the
Because
document.
I know of two cases where there are two people living together, they are not spouses. One used to live here, they are two women living together, another is a man and woman living together, they are not spouses, so only one, and they challenged it,
here in the
not
association.
here.
Okay.
They,
It's a, and
in
again,
Cook County, and they won,
okay.
they won big time, so.
Were they
I
challenged?
don't wanna open, I don't.
Just, we will check it
You know,
out.
Yeah, I think, I would say we can refer this back to legal counsel and ask them for clarity. There's absolutely no problem with that.
Sean, did we check this week on this one?
I don't think I got exact language from him on that one.
Okay, thank you.
So Jody, this is Bill, and I underscore what you and Dave said. I think that underscores, that last comment underscores the need of this very process, right? So that we can gather all the feedback, have these town halls, and maximize these next 2 or 3 months to try to build the maximum consensus and the buy-in, so that when the vote occurs, it has the best chance of being successful the first go-round. I mean, that's what we're doing here.
Thank you.
Thank you, Bill.
That was Bill Doran, member of the commission.
Marty Clark, 1142. I just wanted to say, when you were talking about the last time we passed the covenants, the original covenants required us to have signatures of every owner on the lot. It therefore took 3 years to do that. It was not a simple vote like this is. This is going to be a vote. And I would say when we passed the bylaws that were done to go with the covenants last time, we either got the 2/3 vote or we didn't. That is why when you publish whatever the final edition is of this, after all of these conversations, that's what you're voting on. If you don't get the 1,800, I don't know why you're going through continue voting.
And this is what I was talking about on the mathematical probability of passing or failing.
And that's basically what this vote is
And it
going
could
to be.
take 3 years.
People are either going to agree with what your final version of the covenant is, or they're not.
But we also have to get people who didn't vote at all, and that's part of the process. It's communicating with those who did not submit a vote. So we keep record of who voted and who did not.
Okay, yeah, you can continue to see if you can get.
And
them
that's
to
the
vote.
same thing. They did phone calls and emails and things to those people. And it's true, it did take 3 years last time, and I believe Sean talked to a homeowner association, that it took 6 years.
It took 3 years in the writing, it took 3 years to pass it, and it took 3 more years for it to go into effect. So it was a 9-year process.
Okay.
Thank you for your comments.
Any other comments on this?
Stan Holstuck, 7A113. Just for clarification, will the votes yea and nay be published in the Apple Core each month as they're going through? And it was covenant things, it was never the nay votes, it was just yea votes.
Oh,
Yeah, I would think. We haven't asked legal counsel that yet to find out exactly how we publish all of that, but, I mean, that's something we could
People
do.
would like to know.
Yeah.
Yeah, I think, we have to check with legal counsel to determine whether we publish after every meeting what the count is versus publishing every month what the count is. A running tally in a publication is kind of awkward,
it has to be in the meeting.
but, if you're publishing after every meeting, just, to show where you're at and how you are in relationship to your benchmark, that may be more appropriate.
As long as both numbers are put out.
Oh, absolutely. There's
Just the phone number makes people kind of suspect.
Oh, no, absolutely. You publish both yes and no answers, and you publish the number of people who haven't responded. Absolutely.
Much better than the last time.
Thank you. All right, now are we ready to go on to the new information? Anything on Zoom or Facebook Live? Okay.
No. Want me to stand? Okay. All right, I'm gonna take Article 6, which is the covenant to pay assessments, okay? And if you wanna go to your comparison, the comparison of the declaration document, I'm gonna start on page 14 is where we start, on the bottom of that page. Okay, I'm gonna start with section 4, changes in basis and maximum annual assessments and special assessments. The changes here are related to the updates and definitions of owner, association, and voting member, okay? Section 5, special assessments not included in the annual budget. Changes a written notice adding that not less than 10 days, but not more than 30 days in advance. That's the only change that we have there. Okay, there was old language section 7, which was deleted, and this deals with quorum. Quorum of any action authorized under section 4 and 5, SECA section 140B1. The quorum required for any action required to vote under sections 4 and 5 hereof shall be 20% of the voting members eligible to vote at such a meeting. This was deleted because sections 4 and 5 require a majority vote for total voting members having a quorum of 20%, would suggest that passage only needs a majority of voting members actually voting rather than all the voting members. Because of this, legal counsel deleted this section. Can we get through this section and then we'll take questions after, Marge? Is that okay? We'll do them after each section, or each article. In section 8, proof of payment, old language stated that the service fee could not be more than $25. We did not want it to be tied to an exact rate for a service fee. And since the board approves the fee schedule each year, we changed the language to reflect the actual fee schedule. New language adds, a reasonable service fee as determined by the board, and shall at any time furnish to any owner liable for said assessments or certificate in writing signed by an authorized agent of the association setting forth whether said assessment has been paid. Okay? So we can now set any fee that we want to for that. It's not limited to $25. In section 9, effective non-payment of assessment, the personal obligation of the owner, the lien, the remedies of the association. The old language did not allow the association to collect attorney fees until the association filed for foreclosure of the lot. This resulted in the association not being able to charge an owner whose lot had a lien filed but paid the assessment before the foreclosure was filed. So we file a lien in May, and then we usually foreclose in October or November. So between those times, there's attorney fees, there's interest that we charge, and some of those fees, the majority of the attorney fees, when we get the invoice from Key and Costello, they say, do not charge the owner until foreclosure. We actually do get people that after we file a lien, will pay their assessments before we foreclose. And if that's the case, we actually have to eat that money at this point because of what the old language states. So we're changing that language to now say that those fees can be added, and if they decide to pay in September before foreclosure, they would still be responsible for the fees that we have incurred from the attorney at that time. Okay? I gotta go down and see this. That's small. All right. Deleted language replaced with the following, page 16, was on attorney advisement and added provisions which are typically included in a section outlining an association's right related to unpaid assessments. Any assessments for installations thereof, other charges or expenses including but not limited to annual assessments, special assessments, and duly imposed fines, which an owner is required to make for or is liable for hereunder, which are not paid when due, shall be deemed delinquent, and the board shall have the right to assess a late fee for the delinquent payment. Additionally, and if an assessment charge or expense is not paid within 30 days after the due date, the board shall have those rights and remedies to enforce such collections as shall be provided or permitted by law and equity, including but not limited to bringing suit for and on behalf of the association to enforce collection of the amount due. The costs of said suit and other fees and expenses together with interest including but not limited to reasonable attorney's fees and managing agent fees associated with collection of unpaid assessments, along with any of the interest, costs, and other sums and set forth above which the association is entitled to receive, without limited to foregoing if any owner shall fail to pay assessments, charges, or expenses required to be paid, the board shall have the rights and remedies. Okay, so that's the new language there. Okay, section 13, restricted lots. The language is proposed to remove the ability to restrict a lot, but grandfather the lots that have been restricted. And then Exhibit C has been created to show the lots that have been restricted. Okay, so restricted lots are those lots without any structure erected on the lot and for which an agreement has been entered between the owner of the lot and the association, wherein the owner agreed that said lot shall remain forever vacant, open space upon which no structure of any kind shall be erected except on requested by the association and agreed upon by the owner and the board. Okay? The list of approved restricted lots is attached on Exhibit C. Lots which have previously been approved by the board as restricted lots may remain as restricted lots unless the owner of the lot and the board agree to rescind the restricted lot agreement, in which case the lot shall be treated in the same manner as all other non-restricted lots for assessment purposes. No additional lots may be granted restricted lot status following the recording of this declaration. Okay? Okay, now I'll take questions on Article 6.
Article 1142, I have a couple questions. One goes back to the deleting the quorum. I don't think the 20% quorum is too much to ask when you're talking about voting on assessments and budget items. A quorum of 20% of this association is 549 votes, and a majority of that is 276. That is a very minimal requirement when you're talking about assessments and budget items that 4 and 5 deal with. So I really think the 20% quorum should be made. Second, in Article 6, Section 7, that was the quorum. Section 9, B, and C. I have questions about why it's written in here that the board shall have the power to bid in the interest of foreclosure sale and to acquire, hold, lease, mortgage, and convey any interest so acquired. And then it also says, to the fullest extent permitted, any court shall be authorized to restrain the defaulting owner from reacquiring his or her liens at such foreclosure sale. Why would the association want to do this?
We actually do that now. We have to bid at the sheriff's sale, and we have to own the lots before we have our auction.
Why do we have to do that? I don't recall if we've ever had to bid on those properties at the sheriff's sale.
That's a change we made, 3 or 4 years ago.
Who made the change?
Key and Costello.
Why?
Because if we own the lot, I'll have to get this, and I didn't have time to get with your questions today. I can respond to you and put it on the website, why exactly we did that. But that's what we do. We actually go to Galena and sit in there with Sheriff Turner, and typically it's only us, and then we put a bid on the lots. And this is done usually 30 to 45 days prior to our lot auction.
Okay, and we also have written in there, in the new language, this is all new language.
Yep,
that
correct,
I'm assuming Key and Costello put in.
correct.
The right to take possession of such defaulting owner's interest in their dwelling and lot to maintain for the benefit of all the owners an action for possession in the manner prescribed. Essentially, what we're saying is, you lay claim to this through the foreclosure, we are then recognizably the owner, the association is. Association can't pay dues on a lot.
Correct.
So you won't be collecting any dues for as long as the association holds this property, correct?
Correct.
And was any discussion held about how long you would intend to hold this property, lease it, collect rent, do whatever? Because this language would allow the association to do that. I don't know why we would want to get involved with that.
Well, I think that language states, or I think is in there for if we ever were to foreclose on a house, which typically the association would not do, the bank would do that. So if the association foreclosed on a house for some reason, they could lease that house for revenue in the event that they are trying to sell that house, but before they can sell that house, they could rent it then, lease it out, so.
I understand that. I'm just
Okay.
curious about whether any discussion was held in the legal commission about any length of time or however many limits. Was any of that discussed with regards to this language?
No, we didn't talk about any limits at all. I think if we did, I mean, if the association took a house, I would think they'd want to get rid of it as soon as possible. I don't think the association wants to get into the leasing business.
I hope not, but you never know.
So,
People might consider.
One other dynamic to what you're speaking of, you can have a tax sale, or you could wind up with a share sale. But you also inevitably could wind up with that parcel being owned by the county trustee. Now, there are associations out there, there are 2 or 3 that I know of personally, where the trustees in those counties own upwards of 100 lots. Try getting the trustee to pay dues on those lots. Ain't gonna happen, it's not gonna happen.
I totally understand.
But if we bid on those lots and pull those back into control, then we can auction them off and bring those back as viable paying dues entities.
I guess what I would really
Right.
like is an answer as to why Key and Costello says this is a necessary step when it has never been done before and it has worked
Sure.
smoothly the other way.
that's fine. Yeah, I had ILAC today,
I believe
so.
this is also what Galena Territories does, it's their process.
Yeah, and Key and Costello
Territories
does
process.
those two.
Right,
I'll have that information for you.
We're not the Galena Territory.
Right. There are some associations that will not bid on any of the real estate in their association, and it becomes a very big disadvantage for them because they start seeing attrition numbers that are atrocious.
Galena Territory didn't used to even participate in an auction, and they began that just a few years ago.
Certainly.
And there are real estate people who are very unhappy about that because it has caused land values and property values to stay low.
I buy and sell property, and I tell you, if I was going to be an upset real estate individual about an auction where an association was buying, I would be there and bid against them. It would be that simple. These are public auctions, and if I felt that there was 3 parcels here at Apple Canyon that were more valuable to me than to the association, I step up and I'd outbid him on them. That would be what I would do. So it's right, but I say, if they're upset, if the real estate professionals are upset, they can step up and bid on it.
So what I hear is Marge would like the process and, why we changed the process based on Key and Costello's recommendation.
Hi, I'm Don Ford, 13A 125. I had a question about the restricted lot. I just wondered how many restricted lot applications have been granted since 2015?
Well, I think zero since I've been a member.
Yeah, but I think it's,
That's my question.
yeah.
You know, it says that you have the
There were
right
a
to
few.
apply for one. And if I'm not mistaken, there was a board resolution dated November 21st of 2015, which outlined 4 criteria that the board could restrict or refuse a restricted lot. Why, and there are such things as enhance and preserve the sensible space, et cetera, et cetera. But the biggie is number 3, which says granting the restriction will not have a negative impact to the association finances. So my question is, if you're gonna grant a 60% assessment fee instead of the full one to a restricted lot, how can anyone possibly get a restricted lot approved?
Right.
Which brings me to my next point, which is basically what the board did at that point in time, is they changed the covenants. That is not the process that is listed in, I believe it's Article 9 of how you go about changing the covenants. So my question is, why do we bother to have covenants and bylaws if we're not gonna follow them? And why are we gonna bother to do these again to bring them up to date if we're not gonna follow them? So what about those, I have no idea how many people have made requests for restricted lots. I think there's 107 that are approved, but all of those were before 2015, I believe. Right. So, again, it's just a question. It seems to me like the bylaws and covenants have not been followed because the board literally changed the ability for a restricted lot to even happen by single vote board action. What's the legal opinion on that?
Well, I know at the time, and that was prior to me getting here, but I know at the time that they went out for 3 opinions from attorneys. So, and that was at the time the current legal counsel, actually, Key and Costello was one of them also. So I can get you those opinions. I can email those to you, Don, so you can see what those are, and I'd be happy to share those with you.
This doesn't affect me personally. I wasn't one of those people that applied for them since after 2015, but it bothers me that we have these covenants, we have these bylaws, and we changed one of those with a simple board vote. That just ain't the way it's done, I don't think. I have a suggestion as to how that could happen, and I'm sure this might not be popular from a fiscal standpoint, but personally, I think that all those people who applied and had that turned down should be given the opportunity to have that reassessed. And then you can grandfather those, and I don't care whether you wanna take the restricted lots out. I get that, that's a drain on the finances. I get it. But my point is, you had a rule in there that allowed people to do it, and then by a single board action, you changed what the covenant said. And that just isn't, in my estimation, the way it ought to be done.
I remember conversations on the interpretation. It says the board may approve.
I fully agree.
That was what it was. It was may, but.
That action, November 21st of 2015, made it impossible. Granting the restriction will not have a negative impact to the association finances. That's directly opposite of what it says in the covenants. It says you get a 60% reduction. So by making that change, you made it impossible. Not you, but the board made that impossible at that point.
So now in your opinion, does the proposed changes eliminate the problem?
Correct, but there's people who applied for this.
I understand exactly what you're saying.
Based on a single board action that, to me, was illegal.
Certainly. I understand exactly what you're saying. Unfortunately, I wasn't a member before 2015, and I can't travel back in time and argue with the board about their actions from 5 years ago. But, you know, as a diligent member of the legal commission, I can say, well, maybe this needs to be corrected, and I think that's what they tried to do here.
And I fully agree, and I think the idea of eliminating the idea of having the restricted lots is perfectly appropriate from a financial standpoint. And as I said, this is not affecting me personally at all, but the fact that 5 years with the people who applied very appropriately for a lot restriction were denied because the board at that time made a restriction that basically truly did change governance. So, I don't know how the legal commission wants to address this personally. I think that those people that were affected by this should have the opportunity to have their restriction approved if they still want to do it. I have no idea what the financial implications of that are, how many of them there are. There's 107 of them that are already approved. Obviously, grandfathering those in, but I think those people from November 21st of 2015 till now kind of got shafted illegally.
Okay.
So, just a suggestion.
Let me get some answers for you. I'll let you know.
Thank you.
You bet.
Okay, any other questions on this section, or we will move on to section 7?
I have one from Zoom.
Yes?
What is the benefits of restricting lots? Why do we feel that taking this option away from landowners is necessary? Want me to take it? I would say, I mean, the biggest reason for not having restricted lots anymore is the financial implications to the association. With the 107 lots that we now have restricted, we lose $50,000 a year. To date, we've lost $350,000 to the association just for restricted lots. So that's the biggest one. And that's the one that we typically say this is the reason that we do not want to restrict lots anymore. So. Any further take? No? Okay. Okay, Article 7.
Now we're gonna move on to Article 7, just to deal with the AECC. Well, they've seen my face pop up a few times, and they're like, oh boy, this can't be good. The changes that were made in Article 7, the focus on almost all of those changes were to comply with changes in state statutes, or what's most commonly referred to as state law. And most of these changes were affected by the Not-for-Profit Act. So when the Not-for-Profit Act started making changes and clarifications, there were some things that had to be adjusted. So one of the things that the legal counsel had asked us to, look at and clarify was the general, the general section, the very first article, or first paragraph under Article 7, which talks about land usage. And that's not just land usage for individual parcels, that is the entire group. This is common, reserve, this is individually owned lots. This is the whole thing. That one paragraph addresses that entire combination. So I noticed they say, up here on the slide, it says prohibiting. But if we look through here, there was one sentence added in that paragraph that actually provides a little bit of latitude, and I know there was a question regarding that section. But the latitude goes to an improvement on some of these properties that are restricted or common. It could be something simple. It could be a $100 improvement that somebody does to a common area next to their lot. But what if it's planting a tree? What if you want to plant a tree somewhere, and it happens to be in a common area. Are we saying we're not gonna allow somebody to plant a tree if they're willing to pay for it? But they're enhancing a common area. So, what they're saying is, originally, the language said that, this was to be approved by the AECC. But this added language also required the additional 3 members for a total of 9 board members to help make that happen. So instead of 6 board members for the AECC committee making that change themselves, it actually kind of involves the board through that process. I know that there was one question regarding this language and saying, well, would this, not require a capital expenditure? Not every improvement could be a capital expenditure. Maybe not every improvement could be funded by the association. I've seen some improvements that are actually funded by property or private organizations. So that was pretty much all they tried to do, is clear up and clarify the language on that. If we go to section 3, and we look at this one little paragraph here, this just kind of cleans up some language and gives us some options. Here at Appleton, we have the privilege of having an architect on the committee we've been able to appoint him. He's a member, he could be appointed to that committee. So God forbid, what happens if Joe moves, or Joe's no longer available, and we cannot find an architect or a licensed engineer that is a member of the association to appoint? We should still be able to find a way to provide that same quality, the same due diligence, and the same resources to the AECC committee. And all this language does is give the board the privilege of hiring a qualified individual to advise the AECC committee. Joe has been doing that for several years. We've never had that issue. I know other associations that have to hire outside because they don't have anybody qualified inside to take an appointment or that will step up and do the job. So here they're just looking to, keep providing what they've done in the past and have an option to do so if we don't have anybody we can appoint. When we go to Article 7. If we go to Article 7, this again was changes that was completely dictated by the Not-for-Profit Act. The Not-for-Profit Act had draw a line and saying who can and cannot make decisions for the association and what are you going to call these people. So the legal commission is a legal commission. Before, years ago, all the committees were all committees. But now with the new definition of committee from the Not-for-Profit Act, a committee has the right to make decisions on behalf of the association. That's why they changed that division from committees to commissions and divided that. You certainly wouldn't want the legal committee, the legal commission being a committee and making decisions on guys' behalf. I mean, certainly don't want that. But with AECC and with the nominating committee, they do make decisions on behalf of the association. Not every single building permit or request that goes through AECC comes to the board for approval. They would be there for days just going through and approving and reviewing documents. I don't think that the board wants to do that. Their meetings are already an hour too long, right, Bart? But then it also goes down to enforcement action. What if you have somebody that's violating the rule that was adopted a couple of years ago on property maintenance? What if you have somebody that's violating one of the sections of the covenants and restrictions, and AECC is responsible for enforcing that? The AECC could not enforce that if they were not a committee. It would have to come to the board for the board to enforce it. So at that point, why would you have the AECC committee if the board's reviewing drawings, issuing permits, writing violations? At that point, you're just eliminating an entity and doubling the workload on other people. Where we have members of the AECC committee that are not on the board that help share some of that workload. We get through here, the liability of the AECC and the association, this language is added by the attorneys. This has, through many, many years of case law and all kinds of crazy things things that have been going on in condo associations, homeowners associations, communities. This is nothing more than an indemnification clause. This is saying that if I decide to build a house and I hire a builder and I hire an architect and they're both idiots and the plans are full of defects and the house falls down, that I can't hold the association responsible for it. That I'm not gonna come back and say, I'm gonna sue you guys because the AECC committee approved my plans. No, your plans were defective. We're not going to, succumb to that. Right after we're finished. Thank you. Then we get down to satellite dishes and antennas. This was to conform with, some FCC regulations that go all the way back to 1996. If people think satellite dishes are going away, they may. But keep in mind that Starlink just launched another 60 satellites yesterday. Yeah, they're going to get satellite dish for broadband communication. So we're going one direction, they're going the other direction. So, are they going to go away? Maybe, maybe not. New language in here that was written for remedies on approved alterations and additions. This is what happens when somebody does something. This is addressed what happens when somebody does something that they didn't follow the standard procedures and the protocols that the association has outlined in its governing documents. All of them, the covenants, restrictions, bylaws, AECC, board policy. Somebody builds an addition without a permit. There's got to be a way to remedy that. Otherwise, you have everybody doing it, and what do you do then? Then you have a problem. I'm not going to go through. There are three things in there that are listed on pages 21 and 22 of the document that talk about the remedies. I don't want to sit here and just bore everybody with all the legalese on the remedies, but this helps establish the guide and a protocol for what the association can do to remedy the problem when the problem comes up. And it will eventually happen if it hasn't already happened. If somebody thought about putting it in here, it's going to happen. There's no doubt about it. So, talk about clarifying language. And we've talked about all of the issues that impacted Article 7. There really isn't anything that the legal committee changed in Article 7 to suit the association or anybody. These were all recommendations to conform to current state statutes. There was nothing really exciting in this section, but I like saying conformity, so I thought it exciting.
Any questions on Article 7?
With the architectural thing, do we still have a thing required that people doing the contracting and stuff have to be licensed by the association?
That would be a matter of operations and policy that is not covered by this. So I can't answer that question. That would be a question for Sean or for somebody from AECC to answer that question.
If we don't have an architect and if somebody's not doing it, we approve those architects or contractors, couldn't we then be sued?
Right, and there's also one little catch. And I believe Barb and maybe some of the other people will remember this. I challenged the AECC committee on this about 6 or 7 months ago. And Joe's response was, Dave, I don't think you understand exactly what I do. I inspect for conformity to our declaration. The county building department inspects for code and quality. So that's where, if it's the wrong color, we got a problem. That's on us. But if the roof falls down after the building inspector from the county been there, that's kind of them.
It has been thought about and worked through the city.
Oh, absolutely. In fact, I brought it up and challenged the committee with it about 6 or 7 months ago.
Yeah, because I can see that could be a problem if it wasn't. Thank you.
Mm-hmm. Well, it's in our book, but Joe Davies County doesn't require it, and I know that Rick said we did not need it.
Do we have architect's signature on the plan?
So, but that was one of the first questions I asked Rick Tolson when I bought out here, when he was still a building inspector, was whether or not the plans need to be architecturally stamped. My drawings are from a Canadian architect. So, his signature, whatever, is not valid anywhere.
I believe we added that language to AECC that we needed architect stamp, or did we remove it
Decided not to, because that was gonna add extra cost.
to the owner?
Right, it was gonna add extra cost, and Joe Davies County does not require it. It was one of the items on their exclusionary list.
Okay. Any other questions?
Okay, again, just a quick clarification. What's the difference in meaning between sentence 3 of section 3 and sentence 6 of section 3? Sentence 6 has always been there and has said the AECC, subject to the board's approval, may engage such inspectors or agents to assist it in the performance of its duties and responsibilities, which means we have hired outside consultants or whatever. So what's the difference with what basically is said in 3 and what is said in 6?
I guess the question would be the word engage. Does engage mean that we hire them, or we're putting them on retainer? How are we making that relationship? Is it informal, is it formal? They clarified the appointment versus hiring. When they put the word hire in there, this makes that portion of it pretty clear that the association is gonna have to come up with an expenditure. I believe the other word that you were talking about is not clear that there's going to be an expenditure.
Well, it says to appoint an architect, licensed engineer, or building contractor to the AECC. If they're not able to do that, the association may retain one or more of the same from time to time to consult and advise the AECC in the performance of its duties. Retain implies a fee, does it not?
It does in that case, yes.
So what's the difference between these two sentences and why the need to insert 3? Excuse me.
Okay, and then,
Did the original language specify that the AECC committee could solely engage, or did it require the board to do so? That would be my
it
first
says the
question.
board shall appoint. So
The board shall appoint.
you can look into that one.
Yeah. We'll bring that back
It's
to
kinda hard to
legal and
try
ask them.
to go through this and then find the document where I have the legal, counsel's feedback on that. We'll get back to you on that. Any other questions? Tim, anything on Facebook Live? Sean, anything on Zoom?
No.
Okay. We'll move on then.
Hold on one second. Okay, Article 8 is, water facilities, and really, there's not any changes, major changes. We add some key sheaves, some neutral, gender neutrality, and then some lots. Now, Marge did send a question to me this morning, saying that, Illinois, set availability, consumption, and usage, rates may be billed quarterly, semi-annually, or annually at the option of the serving public utility. And she said, why doesn't it say monthly, since you guys all get a monthly bill? I don't know why, it's old language, but it makes sense to add monthly. I'll bring it to legal, and we'll make sure that there's not something that I don't see right now, but, that's why we have nothing on, Article 8 at all, because really the changes is very small to water service. And then for Articles 9 through 11, there's a lot of new language here by legal counsel. And I asked him just to kind of give me a brief summary of why, and, what he said is that the language is added to fill some gaps with current declaration regarding maintenance and repairs, enforcement of the declaration provisions, and interpretation of the declaration terms, okay? So I'm gonna go through these and just, where there's new language, explain, why that language was added. So, but as you're following along in your document, the comparison, and you see the colored language, you'll see that, starting on section 4 of Article 9, it's all new language by the attorney, okay? So, Article 9, General Provisions. Section 1, the change in language was revised to match the notice requirements of SECA, 160-40A. Section 4, no waiver. This is new language. The new language takes the place of part of old language, Section 3, enforcement. It basically adds a typical provision regarding the provisions of the declaration not being waived by lack of enforcement. More language of enforcement was added to Article 10, Section 1, which is on pages 24 and 25, which we'll get to shortly here, okay? Section 5 is gender neutrality. The new language by the association attorney adds typical provision regarding the use of the terms within this document. For example, he, she, they. Under Section 6, the rule against perpetuities, the new language added by the association attorney is typically included in this type of provision concerning the rule against perpetuities, which is an old legal rule providing that restrictions against real estate cannot last forever. Basically, what the rule requires is that any document containing restrictions on real estate must name a specific person, and those restrictions shall last until 21 years after the death of the descendants of that person that are living at the time the document takes effect. Our attorney selected Tom Hanks, okay? And we've asked why, but that's this rule, okay? He picked him because he's non-controversial. That's why. So when you read it and you say, what is this? This doesn't make sense. It's legalese. Tom Hanks is somebody that hopefully everybody likes. Bill Doran threw out Kim Kardashian yesterday, and I don't think that's on her.
No.
So.
No.
That's what we've got. That's the explanation as to why this is, so. Section 7, liberal construction. New language adds general provision regarding how the terms of the declaration are to be interpreted, okay? Section 8, headings and captions. New language by the association attorney adds a typical provision regarding the headings used in this document. Section 9, waiver and release of claims. The new language added is typical waiver provision. Hereby, each owner waives any claims he, she may have against the association or other owners for damage to the extent insurance proceeds are available for the damage. Okay. Section 10, under security, new language added as a general disclaimer provision which provides that the association is not obligated to provide security, but if it takes any types of security measures which is not obligated to do, this does not mean it is a provider of security. So we have security. We're not suggesting that we're going to take away security, but this says that we are not obligated to have security here, okay? So we're not putting this in to say, hey, next year we're taking security out. It's just to say that it's not an obligation of the association, okay? Any questions on any of Article 9? Okay, Article 10 is remedies. So, I'm sorry, was there one?
I wasn't sure if Edie was getting up. No? Okay.
Okay, none from here on Zoom or Facebook. Okay, Article 10 is remedies. Section 1 is enforcement. This language was moved from Article 9, Section 3 with a general enforcement provision regarding the association's and each owner's rights to enforce the terms of the declaration. Section 2, board self-help. This new language added by the association attorney adds typical provisions regarding the board's ability to take certain remedial actions without having to file a lawsuit. For example, an owner leaving a garbage garbage on the lot and the association removing it. This section would not, however, permit the association to remove an item of construction from a home without a court order. Okay? So, if an owner left their trash cans out on their lot and the association had to pay to take care of those trash cans, we wouldn't have to file a suit in order to claim if we wanted to charge them for it, okay? Section 3, managing agent fees. New language added, which adds a language specifically permitting the association to charge back fees charged by a management company with respect to collection of unpaid assessments and outlines certain actions the manager may take with respect to collections. Okay, so this goes into what we can collect and what we can do from the management side. Fees associated with mortgage foreclosure. This new language added provides that if the association chooses to file an appearance in a mortgage foreclosure lawsuit in which it has been named a defendant, then the fees and costs incurred by the association could be charged back to the owner that was named in the lawsuit. And that's Article 10. Any questions on any of those? Okay. Article 11, maintenance, repairs, and replacements. Number 1, maintenance by owners. New language adds specific provision requiring owners to keep their lots and homes in good condition and repair. Section 2, the owner failure to maintain. This is new language added, that typical provision regarding the association's remedy if the owner fails to keep his or her home or lot in good repair. There is language in the building code now about this, but this also with the declaration helps us too, okay? Section 3, willful and negligent damage. This new language adds a typical provision permitting the association to charge back any costs it incurs to repair damage to the common properties caused by an owner or his tenants. So if an owner does something on the greenway space or common properties, we're allowed to go back and collect the cost. And that's it. Any questions on Article 11? Okay.
Okay, so, first of all, again, it's really important for you to write down your questions. We've got a few of them that we said that we would get back to the owners on. And again, I hope you see, in the process, from the last meeting, changes that were taken back to legal. Our next legal meeting is, October 15th. And again, we have a board meeting, before that. So we take back the board's questions, and then also we'll consider any new questions received tonight.
I had a question for you. I was interested in,
Can you come up here, please?
Oh, sure, I'm sorry. Hi, Deb Anthony. I was interested in pets and nuisances. Were you going to discuss that at all?
No, we can. Should we?
I have something prepared. So if I could just read it and then I could
Get it to us, yes, that's perfect.
I made a copy for you.
Okay, thank
And we talked about pets and nuisances at the last meeting, correct?
No,
Oh, was it this one? Wait,
no, we
Oh.
already discussed it.
yeah, last meeting,
Oh,
okay.
I'm sorry, okay, I didn't hear it. Okay, I prepared a statement.
Okay,
This is a response to the proposed ACL amendment outlawing chickens. And I would say what I am proposing is make it a restricted use, have reasonable requirements and setbacks from the lot lines in order to govern it. But here I go. All right, here's my question. Chickens are a superior backyard pet. So why is the ACL board trying to outlaw them? Why not dogs and cats? Why are they okay? Some comparisons. Feces. Dog feces do not enrich the soil. It does not have the right nutrients, might contain parasites and bacteria, does not break down. In contrast, chicken feces is sold as a premium organic fertilizer of all animal manures. It has the highest amount of nitrogen, phosphorus, and potassium. Noise. Some dogs bark incessantly with no owner control. Roosters are a source of irritating noise and should be banned in residential areas. Harmful to wildlife. Cats. National Geographic reports that domestic cats kill between 1 to 4 billion birds per year in the lower 48 states. 1/3 of the total kills. Feral cats kill the other 2/3. Dogs. Unleashed dogs chase and disrupt wildlife and other domestic animals. Chickens are popular in residential communities. The state of Illinois does not keep a list of towns and cities who allow backyard chickens because it is a local issue. I used a 2015 list from backyardchickens.com, added a few towns to it, and reviewed each of their zoning ordinances. All communities listed do indeed allow chickens to be kept as pets. This is not an all-inclusive list, and just an example of the many communities that allow pet chickens. I could have added a lot more towns and cities, but you'll get the picture.
Thank you.
Chicago and all of unincorporated Cook, St. Charles, Naperville, Downers Grove, Oak Park, Deerfield. Pretty good towns. Evanston, West Dundee, East Dundee, Elgin, Warrenville, Western Springs, Fox Lake, Decatur, Quincy, Pekin, Urbana, Antioch, Lombard, not on the list, Springfield. They had chickens in the governor's mansion. So most of these towns and cities are located in highly populated areas. ACL is located in rural Joe Davies County, which is even more conducive to backyard chickens. Many of us moved here for the country life that provides so many wildlife adventures. I heard the cows move all day since we were surrounded by farms, and they also have chickens. If there is a groundswell of support to eliminate chickens, I would be very surprised. There is a tendency to overregulate at the request of a local few. Allowing chickens in residential areas has gained a lot of support in the past several years across Illinois and the Midwest. I want ACL to always be moving forward, not stuck in the past with preconceived notions about our feathered friends. And I wanted to say a disclaimer. I have never owned chickens and never will. We spend the winter in a warm climate, and chickens are not good traveling companions. So, thank you for your consideration.
I grew up with chickens, and I tell you, I would never have another one. No way.
I think we just found the person who doesn't like chickens.
I like chicken, breaded and fried.
Send this to me, electronically so I can forward it to the commission.
Great.
Thank you.
It is an interesting topic to bring up. I guess it's personal preference, you know?
Right.
I guess it depends on how many people are for and how many people are against.
It also depends how you regulate. It's been, I've done a lot of research on the subject, and it's highly successful in all of those communities.
Yeah, if they're growing up with chickens, I could find it. The only thing I could regulate was sleeping.
Any other?
I have another question. I'm sorry.
Come back up, Deb, because people on the Zoom cannot hear you from the back of the room.
You can't teach an old dog new tricks.
I know, well, it's hard, I couldn't
I
see
can't
you.
remember to get up here. Okay, Deb McAfee. I had a question from last week, and I'm still not clear on it. So, you have your house, and then you have a lot next door. And when you guys were talking about they're connected, how do you connect them? You do it with the assessor office, or what is that about?
Are you talking about lot combination?
Yeah, because you're saying you can't put a fire pit on the lot next door.
It's called a lot combination. You fill out a form, you submit it to AECC, they review it. If they approve it, they send it to the board for final approval, and it's lickety-split. I have not seen a lot combination here be denied.
Okay, and people, when
You
they
have to file it with the county.
Right, and it's irrevocable. So once you file it, those two lots stay together forever and ever, amen.
Okay, so, I know several people who have lots that are not combined, and they have a fire pit on it.
Right, we discussed this 2 weeks ago, and I think if you're willing to provide a list of names and individuals to the,
No, have
to the
you done any
applicant?
research to see how many people this would affect in the community?
Joe doesn't have the time right now to go through.
No, I'm talking about the administration, I'm not talking about him, I'm talking about people who get paid.
Right, well, and then just, he's talking about Joe, the guy that has to drive around and look at these, he's talking about our.
Well, here's the thing, I didn't know if we had a record, I don't know if we have a plat that we can see, I don't know if we have owners in the computer, but it just seems to me that this could have a really big impact, and we don't even know how many people it could affect. And I just wanna know, what's the reason for it? What are you trying to accomplish?
With the lot combination, this gives you the ability, which I'm gonna be exercising, because I have 2 lots over in section 13, gives you the ability to put a single house right on the lot line of the 2 adjoining
Yeah,
lots.
that's not what I'm talking about.
But, so where are you,
He's talking about a vacant lot. If you own 2 lots and one is next door
What
to
are
you.
you trying to accomplish by not letting people store firewood on a lot they own?
That,
On a vacant lot?
the rationale is, we have a rule in the declarations, you cannot store stuff on a vacant lot without a house built on it. And the intent on that is so we don't have, a lot of storage happening on a vacant lot. And what we don't wanna have happen is having, an owner of a lot who doesn't live here, okay? Just wanna put their boat out on the vacant lot,
Right.
and then when they come out here 2 or 3 weekends in the summer, drag the boat off, put it in the lake, and, woods in.
I'm with you 100% on that.
Hot firewood, nice.
No, this is the thing about, okay, so, one of my neighbors, Moses, has a beautiful fire pit, and it enhances the community. And he gets to use the property he pays taxes on. I think there's a difference between a permanently affixed structure and a structure that you can remove if they sell it separately. So I'm asking you to consider that. Consider a person who owns the lot, and they might want to use it in a passive way. Rather than, I'm with you, no storage, no boats, nothing. But people should be able to use something that they pay for and pay taxes on. And it really wouldn't hurt anyone. If it's very passive, firewood in a fire pit, you know? And if you don't like the way they have the storage, you've got all kinds of nuisance ordinances, even under Joe Davies County. They got a pile up with leaves, you pull the nuisance ordinance.
Some rules and regulations on it.
Right, they're already there. Yeah, they're already there. Thanks so much.
For those on Zoom and Facebook Live, that was Steve Tribby, who is contributing to the conversation.
Thank you.
Member of AECC.
Thank you.
Anything else? Anything on
No,
Zoom?
nothing here. Tim got one on bylaws, so we're just gonna tell him we deal with bylaws next town hall.
Yes, so that brings us to our next town hall meeting is October 21st. We will start on the bylaws, and again, our process is try to, on our slides, to go through it and to explain to the membership of why the change occurred and what the change was. We'll do Articles 1 through 10, and then the following week, we get to come together again with proposed amended and restated bylaws, Article 11 through 15, and continue with discussions and questions. So thank you so very, very much for attending tonight. Thank you.
Good night, everybody on Zoom.
So hard to keep. Because last time, I said about the timeline, and a lot of